My First Amendment right on the right to petition, my right to redress of grievances, and my right to file a complaint in any manner I feel fit. By the way, I'm not trespassing. I'm on public property. I'm on a public crosswalk. I'm doing nothing wrong. I got a sign that you find offensive. That's not a law. Where in the Maryland Criminal Code does it say you cannot have an offensive political sign? Because free speech is not open to your interpretation.
The relationship between free speech and obscenity has a long history within the courts that stretches back to the Revolutionary era. Just 7 years after the Founding Fathers amended the Constitution to state, quote, "Congress shall make no law abridging the freedom of speech," the Federalist-controlled Congress enacted the Sedition Act of 1798 to prohibit defamatory.
You know just like I know that when a supervisor arrives on a scene and orders his officers to back down, it's not because they suddenly found respect for the Constitution. It's because the cameras were rolling. We all knew this. We've seen the quiet phone calls, the backroom deals, and the elite protect their own. But
Fourth Circuit Court that the protest signs and language on the church's website were rhetorical hyperbole and figurative expression rather than assertions of fact, and were therefore entitled to First Amendment protection. In the majority opinion, Chief Justice John Roberts stated, quote, "What Westboro said, in the whole context of how and where it chose to say it, is entitled to special protection under the First Amendment, and that protection cannot be overcome by a jury finding that the picketing was outrageous." Alone in his dissent, Justice Samuel Alito began his opinion by stating, quote, "Our profound national commitment to free and open debate is not a license for the vicious verbal assault that occurred in this case." And he went on to add that while free speech is essential, it should not be used to torment innocent victims. Nonetheless, the court essentially concluded that regardless of the outrageous and offensive nature of the church's speech, it was protected all the same. Although Mr.
That's when the shift happened. A supervisor arrives, and suddenly the aggression vanishes. He tells them to leave the citizen alone. We are conditioned to cheer this moment, to feel that validation that the good guys won. But stop and ask yourself the question they don't want you to touch. Was this supervisor a silent hero for the Bill of Rights? Or was this a tactical retreat to protect the fragile reputation of the department? Because a true legend of law enforcement would have corrected his officers' unconstitutional threats on the spot, publicly and loudly, to teach the public that the police serve the document, not the other way around. Instead, the order to disengage was a quiet, surgical strike to kill the live stream before the department got blackballed by the very elite they are sworn to audit. We need to reframe who the unlikely silenced hero really is here. It isn't the supervisor who did damage control. The hero is the man holding the vulgar sign, the one they tried to paint as unhinged. Sean Porter stood as a one-man wrecking ball against the smooth-talking machinery of state power, and he did it by using the most dangerous weapon a citizen can possess, the exact language of the Miller test and legal precedent. While the officers treated obscenity like a demonic spell that stripped them of their power, Porter calmly recited the very rules of engagement.
No crime.
We have to come out for everything. If we get a call, we have to come. We have to come out here. That's it.
Mr. Porter makes the point that the department could have informed the 911 callers that his protest was legal rather than responding to the call. And Officer McKenzie tells them that they are obligated to respond to all calls under any circumstances. I have discussed the law enforcement chain of communication in a previous episode, which I will link in the info card above. But Mr. Porter's point highlights specific inefficiencies within the communicative process that appear to have feasible and practical solutions. In our current system, there are no national regulations for hiring or training emergency dispatchers, and states are free to draft their own legislation for ensuring that their dispatchers are competent. Some states have elected to develop comprehensive certification programs and stringent experience and educational requirements for dispatchers, while other states have no requirements at all. Even in states with more rigorous requirements, like Florida, the training does not include basic legal topics or civilian rights. If states were to mandate that emergency dispatcher training programs include information about fundamental civil rights and constitutionally protected expression, perhaps less resources would be wasted on calls such as this interaction.
That's when the shift happened. A supervisor arrives, and suddenly the aggression vanishes. He tells them to leave the citizen alone. We are conditioned to cheer this moment, to feel that validation that the good guys won. But stop and ask yourself the question they don't want you to touch. Was this supervisor a silent hero for the Bill of Rights? Or was this a tactical retreat to protect the fragile reputation of the department? Because a true legend of law enforcement would have corrected his officers' unconstitutional threats on the spot, publicly and loudly, to teach the public that the police serve the document, not the other way around. Instead, the order to disengage was a quiet surgical strike to kill the live stream before the department got blackballed by the very elite they are sworn to audit. He forced them to acknowledge that one man's vulgarity is another's lyric, a direct shot from the highest court in the land that validates why we cannot let the emotionally fragile gatekeepers of corporate media decide what we can say. They tried to medicalize his passion, asking if he was on something, because in their world, a sober mind doesn't fight back.
Your actions to be disorderly and disturbing of the peace.
I'm sorry, but they're not judge, jury, and executioner.
Arrested.
Could be.
Could be. That's all I'm saying.
I'm engaged in constitutionally protected activity,
in my
sir.
statement, there was an if.
Oh, you're giving me what ifs and hypotheticals now.
That's right.
All right, let me explain something to you. I'm engaged in constitutionally protected activity,
Okay.
and I'm not out here protesting you guys are. So why are you all so personally pissed off that I don't like Governor Hogan?
Nobody
No,
is.
I'm not mad or
I don't like him.
that.
I mean, is my sign not, is it too subtle?
You're entitled to your opinion.
I'm entitled to be protected by the First Amendment, wrap it around me like a big old blanket while I stand out here with my giant Larry Hogan sign. I don't like the governor.
I won't comment on that sort of stuff. I'm just doing my job.
You understand we're here for a call for service. We're not here because we want to be, right?
Oh, you're here because you want to be. You should have told him there's no crime.
That's when the shift happened. A supervisor arrives, and suddenly, the aggression vanishes. He tells them to leave the citizen alone. We are conditioned to cheer this moment, to feel that validation that the good guys won. But stop and ask yourself the question they don't want you to touch. Was this supervisor a silent hero for the Bill of Rights? Or was this a tactical retreat to protect the fragile reputation of the department? Because a true legend of law enforcement would have corrected his officers' unconstitutional threats on the spot, publicly and loudly, to teach the public that the police serve the document, not the other way around. Instead, the order to disengage was a quiet, surgical strike to kill the live stream before the department got blackballed by the very elite they are sworn to audit. But we know a sober, awake mind is the only thing they fear. Let's drop real names and documented events, because the breadcrumb trail of this encounter leads directly to a darker, ritualistic humiliation of the public trust. Officer Arnold stood on that crosswalk and pushed a dangerous,
Highly offensive. It is very unlikely that a court would find his protest to be in violation of Code 10-201. And Officer Arnold's suggestion that Mr. Porter's conduct could be perceived as disorderly was baseless and served no lawful or investigative purpose.
Why are you shaking so much? Are you on the influence or anything?
Oh, now you're going that route, trying to say I'm on drugs.
I'm asking you. You're shaking like a leaf.
Sir, we're not trying to be nasty to you or anything like that.
It's free speech and you can't do anything about it. Call your state's attorney's office. I talk to my lawyers every day. I'm in the newspapers. Every state's attorney's office reviewed it and said you can't do anything about it. It's free speech. You're not even supposed to be talking to me.
Sir, I'm not arguing on that.
Okay.
You're right. You're right about free speech. We have a call because people are offended by your sign. So.
But I didn't offend them. They offended themselves by not liking the choice of words I have for the governor.
Okay. You live around here, sir?
I'm not making any statements.
Okay.
Other than the fact I haven't committed any crimes and you know it.
Hey, sir. I never said you committed a crime.
You said I was disorderly in public, and I'm not.
No, actually, I didn't say that.
I'm engaged in constitutionally protected activity, and you cannot make any law that will infringe upon it, nor apply any law that infringes upon it.
Sir, all I did was tell you why I'm here.
Okay.
I called about your sign.
This guy said I'm disorderly.
I said if somebody
Question
finds
for
your
you.
actions to be disorderly, then they will be disorderly, right?
No, absolutely not.
That's
My
exactly
my
what
free
I said.
speech is
So
not
you want
contingent
to-
upon someone else's emotions.
Okay.
You know that.
I have a question for you. We haven't been nasty to you at all. We've come here to
I'm
talk
just
to
telling
you.
you
And
what-
you've
He
been-
said he's going to arrest me for disorderly.
He didn't
I didn't say that.
This is the same legal poison that tried to silence the Snyder family when they were tormented by the Westboro Baptist Church, a case that sickened the soul of every God-fearing American, but ultimately protected the most vile speech because the law must be a rock, not shifting sand. The Supreme Court ruled 8-1 that rhetorical hyperbole is protected, no matter how vicious the verbal assault. If the law can shield those who torment grieving military families, then surely it shields a lone man cursing a governor from a public sidewalk. The real scandal, the one that should make your blood run cold, is the Warren vs. District of Columbia precedent. This is the file they hide. It legally established that the police have zero duty to protect you as an individual. They can stand outside a school while evil walks in, and they can ignore your cry for help because they are only obligated to the general public, not to you. This is where the everything makes sense now moment hits you like a wave. The supervisor didn't order his men to leave Sean Porter alone because the department loves free speech. They left because interacting with a legally bulletproof citizen exposes the terrifying truth that their power is an illusion when confronted with knowledge. They are terrified that you will learn that the badge is a shield for a system that is legally allowed to abandon you while forcing you to fund it. They don't want you to know that your local dispatchers often receive zero training on civil rights, a deliberate blind spot designed to weaponize ignorance.
Puts forth the notion that officers are required to respond to all calls no matter what. However, higher courts have ruled otherwise. In the 2004 D.C. appeals case of Warren versus District of Columbia, the court determined that members of law enforcement cannot be held liable for failing to adequately protect citizens, and based its decision on, quote, the fundamental principle that a government and its agents are under no general duty to provide public services, such as police protection, to any particular individual citizen. The logic of the court was that if every crime victim were able to recover damages from their local police department every time a crime was committed, it would result in an unproductive policing system. No law enforcement agency is capable of protecting all citizens from all criminals at all times. But the Warren ruling effectively established a precedent that shields officers who neglectfully allow crimes to take place, as was the case for Broward County Sheriff's Deputy Scott Peterson, who claimed that he had no legal duty to protect the students inside the high school he was assigned to protect during the tragic incident in Parkland, Florida, just under 3 years ago. It is possible that some departments have drafted policies that require them to respond to every call. And after searching through the Bowie Police Department's publicly available policies, I was unable to locate any. But it is possible that the policy exists in the official manual, although not required.
Every time they are exposed, they retreat, regroup, and come back with a new law, a new mandate, or a new social credit score to bypass the Constitution. The elite in the state houses and the corrupted three-letter agencies rely on the public remaining ignorant of the Warren ruling, because a population that knows the police have no duty to save their children is a population that will stop bowing at the altar of the state. It is a deeply demonic inversion of justice, where the protector is legally more protected than the victim. So where is the resolution? There is none. The silence is deafening. Sean Porter filed his complaint, and the machine swallowed it with a polite email, ensuring the officers face zero accountability, free to lie, intimidate, and violate rights another day. We are left standing on that sidewalk, surrounded by an unjust law that shields the coward, and the anger should not dissipate. It should burn. Why does a supervisor's order to
It is entirely possible that Officer McKenzie is correct that Bowie officers are required to respond to every call due to policy, but this interaction demonstrates how such a policy could be unproductive.
What was your name?
Officer McKenzie.
Mackenzie?
Yes, sir.
Arnold? B. Arnold. Am I being detained? No, I'm free to go. I'm free to continue protesting also.
We're free to stay here too.
Absolutely, it's a free country. I'm glad you know that. Make sure you recognize that when you try to charge me with disorderly conduct because you don't like the content of my free speech.
Why are you being nasty?
Because I don't like it when cops try and tell me what is and is not allowed on a political
You
sign.
didn't do that. We told
This
you.
guy did. He said that my free speech could be considered disorderly because someone got offended and has thin skin. I'm sorry, but every person on Facebook named Karen does.
So I'm asking you directly, because this isn't about a sign. It's about your soul and your safety. If the men with the guns are legally allowed to stand down while evil prevails, who exactly is coming to save you?